Good afternoon, everybody. Welcome to the webinar on criminal background barriers to foster home licensing for kin caregivers. We're excited to introduce you to a new resource today. Let's take a minute or two to let everybody join and put your information in the chat so we know who we've got with us today. And then we will get started. Give it another minute. All right, looks like everybody in the waiting room has joined. So again, welcome. My name's Heidi Redlish-Epstein from the American Bar Association Center on Children and the Law. I'm going to let my co-presenters introduce themselves, and then we'll get started. Anna, why don't I turn it over to you? And then we'll hear
Thank you, Heidi. Good to join you all. Anna Beltran, Director of the Grand Families and Kinship Support Network here at Generations United.
And hi, everyone. Thanks for being here today. I'm Stephen Justin Howard. I'm a staff attorney with the ABA Center on Children and the Law.
Thank you. So as the slide said, please put your questions in the chat. You will be getting the slides and recording. Tomorrow, we will also be posting this webinar and the resources on our website, grandfamilies.org. All right, next slide. So for those of you who may not be familiar with the ABA Center on Children and the Law, we are a nonprofit division of the American Bar Association, and we are approximately 22-person team of attorneys and core staff working on a whole host of projects, including kinship, legal representation, improving legal systems in a collaborative coalition building kind of perspective, working with lawyers and non-lawyers across the United States. Feel free to visit our website to get some free resources. Next slide.
And Generations United is a national nonprofit organization located in Washington, D.C. And we have two sides of our Grand Families House, as we call it here at Generations United. So we have the longstanding National Center on Grand Families, which has been around for 25 plus years. And it manages a national network of caregiver advocates. So grandparents and other relatives who are raising children and advocate on behalf of the others who are raising children. They conduct federal advocacy on behalf of the families, and they also create an annual State of Grand Families report, which this year's report is on K through 12 education. It'll be released next month. And on the next slide, you'll see a little bit about the National Technical Assistance Center, which Generations United's now been running for almost 3 years. And Heidi and the ABA are one of our subject matter experts. We also have 5 national partners that we run this initiative with. And you can see the website there, and please sign up to access our newsletter. It comes out monthly and has a plethora of resources, including what's going on in the kinship field that the network hasn't had a finger in, but that we know about. So please access our resources. I'll turn it back to you, Heidi.
Thank you. So today we're going to talk about a new resource, but before I do, I wanted to mention that a website that we all collaborate and co-manage is grandfamilies.org. If you haven't been to our website before, please visit. It is a partnership between the ABA Center on Children and Law, Generations United, and Casey Family Programs, where we like to post different resources. We have topics. We have about 12 topics right now, a database of laws and bills from around the country, as well as our publications and resources. If you've got a resource you want to post, please share it. This page that we're showing you right now, Creating a Kin First Culture, is based on something that we created quite a while ago on WikiHow, that tells you how long ago, on how to put together a kin first culture. We are always looking for promising practices from around the country to add to that page. So please, please, please email us with your resources and information. We would love to highlight you. Okay, next slide, please. So today we're talking about one of our newest resources, our criminal background check barrier crimes and foster care licensing memo that we developed. Came out in early 2024. It's available on grandfamilies.org, and you'll see the link in the chat. Summarizes the 50 state and District of Columbia criminal barrier crime laws and policies. So in comparison to the federal law, the Adam Walsh Child Protection and Safety Act of 2006. And we want to thank Casey Family Programs for their support in developing this resource. I will tell you that just like every other resource you put out there, the minute you publish it, something changes. So I'm going to let you know, we will do our best to tell you some of those changes from the memo, but this is a fast-moving area of law, and I'm excited to say that, and states are really working hard to improve this list of barrier crimes to make sure that we're licensing kin in versus excluding kin from becoming licensed foster parents for their related children. All right, next slide, please. So first, taking a kind of big picture look at foster home licensing in general. So kin, as we know and data sort of supports, are not always licensed or approved to care for children when they are placed through the Child Welfare Agency and in the custody of the Child Welfare Agency. Approximately half the states allow for unlicensed or are not approved kin to care for children while they're in the custody of the state or tribal agency. And as we know that this impacts not only their financial assistance and their ability to care for the child, it also has a direct impact on their ability to achieve permanency with the child. So for states that have things like the Kinship Guardianship Assistance Program, licensing is the first step. Without licensing, you can't qualify oftentimes, at least for federal, Kinship Guardianship Assistance Program. So we really look at licensing as sort of the front door to a lot of the benefits and trajectory and path if a child cannot safely reunify with the family. But what we also know is that a lot of those licensing requirements that you see and that you apply in your states and tribes are well beyond what the federal government had anticipated and or has set out as parameters with regard to licensing. So what we know is under federal law, there are only a few pieces of licensing that are required. One, you'd have to designate a state or tribal authority who's responsible for your licensing standards. Two, you have to have broad flexibility, but they must be reasonably in accord with recommended standards of national organizations. And we know that the NARA standards, which the ABA, Generations United, and NARA produced in 2014, were really the first set of national standards out there. We now have a very exciting other set of model licensing standards that are specific to approving and licensing kin. And Anna's going to talk about that a little later. Another piece of federal law is that states and tribes are allowed to use a waiver of any standard on a case-by-case basis that's considered non-safety. I will say that the federal government did not define non-safety, but left it to the Title IV agency to determine what they consider non-safety. Some states have done that. They've listed out here the non-safety, and others really do it on a case-by-case basis to determine if waiving that standard would still allow the child to be appropriately placed in a safe home of a kinship caregiver. Another requirement is that Title IV agencies periodically review their standards and look at the amounts paid. Something new that Anna's also going to talk about is a new rule that came out allowing for kin-specific standards that also requires that if you're going to provide payment, foster care maintenance payments for kin, they have to be equal. It cannot be a different amount as those non-kin foster parents. And that's under a new rule. The next one is that kin foster homes, as well as non-kin foster homes, must apply what's called the reasonable and prudent parenting standard, which basically allows for normalcy in the home so that either whether you're a foster parent or a kin foster parent, things like allowing your child to go on a field trip, allowing the child to play a sport, these are all considered part of what we see as the reasonable and prudent parenting standard, which is a federal law. And then finally, and that's really what we're going to talk about today, is the requirement that all Title IV agencies conduct criminal background and child abuse registry checks. So that's it. Like what you see in those bullets, that's it. Everything else that you see in your licensing standards are created and developed by state, territorial, or tribal level. It is not required by the federal government. Anna and I, as we have toured over the years throughout the states and talked to folks, they'll say, well, here's the square footage requirement by the feds. And we say, that's really not a federal requirement. That is your state or your tribe requirement. So just knowing and understanding the difference between, as you can see, how little is actually required by the federal government versus what's required in your jurisdiction, really understanding that difference. And today we're really going to focus on that last one, that criminal background check. Next slide. So in 2006, the Adam Walsh Act was passed, and it required background checks on foster parents and adoptive parent applicants, including fingerprint-based checks of a national crime information database, and state child abuse and neglect registries of current states and any past states from the last 5 years. Those are federal requirements that allow for federal financing of that foster home and of the placement. And those are sort of, as we talked about, one of the federal requirements that states have then since taken and added to. Under Adam Walsh, there are 2 categories of crimes which would prevent the child from the home from being licensed as a foster placement for the child. And the first one is called permanent barrier crimes. So a permanent barrier crime would say, if you have this crime, you would not be allowed, with the support of the federal government, to license that home as a foster home, whether you're kin or non-kin. And it's a felony. I want to point out felony only, felony, and there must be a conviction of child abuse or neglect, spousal abuse, a crime against children, a crime involving violence, including rape, sexual assault, or homicide, but not including physical assault or battery. Now, this is sort of a generic list of crimes, and the reason I say it's a generic list is you would have to go to your state's penal code to really see how these crimes are defined in your own jurisdiction. So this is the basic parameter that's laid out by Adam Walsh. It is then translated in your own jurisdiction to be, for instance, penal code number 12345, whatever that crime is in your jurisdiction. And then we have another set of barrier crimes, and that is if you have a felony conviction for physical assault or battery or drug-related offense in the past 5 years only. Again, this is the federal law. This is what the federal law requires for reimbursement for a foster home through Title 4E funds. And that's it. We're going to hear a little bit from Stephen about how states have gone above and beyond what the federal law has required. So I'm going to turn it over to Steve.
Thanks, Heidi. So yeah, let's get deeper into what we found in this recent report that was released when we researched the state policies around criminal barriers to licensing. So I think first it's important to underscore what Heidi said about how Adam Walsh and state laws relate. So states can't remove barrier crimes that are listed in Adam Walsh and still receive funding from the federal government to license those homes. So California and DC are the 2 jurisdictions that do still license some caregivers who would be barred under Adam Walsh, but they can't use Title 4E funds for those caregivers. But a lot of states do go further than Adam Walsh. So they add additional barrier crimes that aren't included in Adam Walsh or extend that 5-year time period for certain crimes before someone can be licensed. So the map you see here and the numbers here are slightly different than what's in the report because there have been a few state law changes recently. But to overview our findings, most states, about 2/3, do add criminal background barriers to licensing beyond what's in federal law. And then about 15 states in DC follow Adam Walsh as is. Maryland follows Adam Walsh, but only adds human trafficking to those barrier crimes. Ohio used to be the same as Maryland, but they recently passed some legislation that added additional barrier crimes to licensing. The other thing I wanted to point out looking at this map here is you can see there aren't really clear patterns about the states that do or don't follow Adam Walsh or add additional barrier crimes. You'll see, across different regions of the country, demographics, standard political leanings, you'll see states that both do and don't follow Adam Walsh. So I think that underscores that there is a lot of opportunity to change these laws no matter what state you live in. And so we'll go to the next slide. So what do these additional state barrier crimes look like? It really varies a lot by the state in terms of how much they're adding to Adam Walsh. So some states have really long lists of crimes that they're adding on top of Adam Walsh. Some states have a lot fewer. And then another way that these state policies can really vary is, as Heidi mentioned, the way that states define what is a violent crime actually varies quite a bit. So some states have really expansive lists of violent crime that go beyond what someone would sort of typically think of as constituting a violent crime. So that can also expand the number of people who might be barred from licensure because of these state laws. So you'll see a lot of states have different timelines. So if someone's been convicted of a crime within this timeline, then they can't be licensed. These 5-year barriers are most common. But even within these states that have 5-year barrier crimes, what's included can vary a lot. So, for example, Arkansas has a list of 64 different crimes that are a 5-year barrier to licensure. Includes things like forgery, theft, obscene performance at a live public show. So really a long list. Other states may include a lot of crimes, but have sort of simpler criteria. So, for example, Tennessee and South Dakota, all felonies that aren't permanent barrier crimes are automatic 5-year barrier crimes to licensure. And then you have states like New Jersey that only adds a few crimes like lower degree assault or drug related crimes that wouldn't be encompassed under that felony standard under Adam Walsh, but they add under state law. So you'll see there's some significant variation there. And then a few states, Nevada and Michigan, add 7-year barrier crimes. Alaska, Illinois, Michigan, and Colorado have 10-year barrier crimes. And Colorado is a little different there because rather than listing certain offenses as being 10-year barriers, their policy is that someone cannot be licensed if they've had a pattern of misdemeanors in the last 10 years. And then I also wanted to flag Texas. They're the one you see there with the 20-year barriers for non-kin only. So other states pretty much exclusively have the same barrier crime lists for kin and non-kin. I know Anna will talk a little more about opportunities with kin-specific licensing coming up. But Texas designated certain crimes, only those that go beyond what's included in Adam Walsh, that are 20-year barriers for non-relatives, but 5 years or non-automatic barriers for relatives. So for example, aggravated robbery is a crime that isn't listed as a barrier under Adam Walsh. But it is a 20-year barrier crime for non-kin, and for kin, it's a 5-year barrier in Texas. But this like differential length really only applies to a small subset of crimes, even in Colorado. Or sorry, Texas. I'm looking at the chat here. And yes, if you do see things where you're like, no, we changed the law recently and that's not reflected, please let us know because we want to be updating these. So we'll go to the next slide now. And let's talk some more about how states are evaluating someone who's seeking to be licensed criminal history in 2 distinct situations. So in some states, there may be a process for applicants who have a criminal background that wouldn't bar them under that would bar them under state law, but not under Adam Walsh. And there might be a process for them to seek an exception or a waiver if it's considered non-safety related and it would be in the child's best interest to license the caregiver. I will say a lot of these state laws that we looked at, it's not super clear how these waivers or exceptions apply to criminal background checks, and it's hard to know just from looking at them how much those are really being used, if at all, in those cases. A lot more common thing where states are evaluating these criminal histories are looking at a licensing applicant's criminal history when they have some kind of criminal background, but they haven't committed one of these automatic barrier crimes that immediately bars them from licensure. So zooming out a bit, when we talk about something being an automatic barrier crime, what that means is if they have that conviction on their record, they can't be licensed no matter what, and they don't look any deeper into it. That's just the end of the road. But for someone who has a criminal background that isn't an automatic barrier, that could still potentially be disqualifying from licensure, even if it's not automatically so under statute. So how states look at that is they typically list some kind of criteria to evaluate how they're going to assess these criminal convictions and if that's going to bar someone from becoming licensed as a foster parent. So in this report, what we did is we looked at these state standards and we compared them to those NARA standards that were developed. And they sort of came up with 8 different points for states to assess criminal backgrounds and sort of weigh the criminal background and how it might impact a potential caregiver's ability to safely care for a child now. So you would look at things like the type of crime that was committed, how long ago was the conviction, how old was the caregiver at the time of the conviction, what kind of evidence of rehabilitation do you have? So things like that. So looking at state standards, we found most states either use all of those NARA standards or some of them. And for the states that don't, which is about a third, I think a lot of them probably are using these criteria and just don't have it outlined in statute, because many will say they'll look at things like the fitness of the caregiver or the best interest of the child, where they'd probably be looking at many of these same factors. So just to illustrate what that might look like in practice, if a state lists driving under the influence or DUI conviction as a barrier crime, then no one with any DUI conviction could become licensed. However, if it's not on their barrier crime list, a state would be able to look at the details of someone with a DUI conviction and decide whether that should be a barrier to licensure. So someone who had a conviction from 20 years ago and they have a clean driving and criminal record since, that's probably not going to be a barrier or something that would impact their ability to become licensed as a caregiver. However, if their DUI was from 2 months ago and they had a child in the car at the time, then it probably would be a barrier, at least could definitely be a potential issue. So if it's not in the automatic list, it's something that states can still consider, but they're going to bring in these factors to think about, the seriousness of the offense and how it might relate to the caregiver's capacity to safely care for children. One other policy, I mentioned a lot of those states that don't use the NARA standards use sort of more general things. One that I did want to highlight as sort of unique was Oregon. It's not in their state statute, but rather in a policy manual. They mentioned that in the weighing test that they should look not just at the factors around the criminal background or the previous conviction, but also the potential benefit of placing a child with a kin caregiver, like their connection to the child, ability to care for the child, ability to keep the child connected to their family and culture and things like that. So really taking a more holistic approach. And now I'll pass it to Anna to talk about more opportunities for states to improve on these policies.
Thank you, Stephen and Heidi. Yeah, so very exciting news. Last fall, a new federal rule was published that allowed states, tribes, and territories that run 4E agencies, so that get federal child welfare money, to create or implement kin-specific foster home licensing standards. So they could have a separate set of standards for kin than for non-kin. So those standards that Stephen just talked about, the NARA standards, we, ABA, Generations United, NARA, developed at a time when there had to be one set of licensing standards for everyone. So we stand by those standards and we encourage you to consult them when you're looking at your non-kin standards, because those families and those providers are so important as well. But there is this new federal rule that allows for these separate foster home licensing standards that are tailored and common sense to the families. Because as we know, kin come to it in a different order than non-kin come to it. So the children, typically get the children before they get the license. And so what we want to ensure is that these families are supported as soon as they can be, with sensible standards that look at the safety of the home and that facilitate the placement of that child and the initiation of foster care maintenance payments as soon as possible. So in an effort to help and to follow that federal law that Heidi talked about, which is that states and tribes and territories are supposed to follow a national model and create their standards reasonably in accord with those standards. So while this federal rule was in proposed state, we got together with over 45 kinship caregivers, over 100 Title IV-E agencies, and a whole array of national partners, including ABA, Generations United, and lots of others, and created these kin-specific foster home approval standards. And the good news is that 9 jurisdictions have already run with this, and they are already implementing that new federal rule. And some are following these foster home approval standards, which jurisdictions obviously can choose to follow in whole or in part, to take pieces that make sense. But the kin-specific foster home standards very closely follow the federal requirements, have tools like a kin assessment, like a caregiver assessment. And then as concerns the Adam Walsh law and criminal and child abuse registry checks, it closely follows those laws. And then what it says, just like the NARA standards, is if the criminal background check or the child abuse registry check turns up something that doesn't automatically bar under Adam Walsh, you, jurisdiction, can use these criteria to assess that criminal background. And that is essentially the same criteria that Stephen just went through. So really kind of following Adam Walsh, which makes a lot of sense, and kind of doing away with these nonsensical automatic bars for providers. We've seen everything. You know, Stephen gave you some examples. We've seen things like writing bad checks 20 years ago, unlawful assembly, just everything you can imagine. And we can't bar kin or non-kin, frankly, for those kinds of offenses that happened so long ago and that were misdemeanors and maybe weren't even prosecuted. At any rate, so that's where we are. We're very excited with the 9 jurisdictions that are moving forward with this, 6 states, 3 tribes. If you'll go to the next slide. We are standing ready, ABA, Generations United, lots of others, to assist any jurisdiction that wants assistance moving forward with those kin specific. There are things that are easier to do in the interim that can make a big difference for kin and non-kin, frankly, including creating easier ways to get the fingerprinting process done and less threatening ways. So a lot of jurisdictions send their kin and non-kin to the police station to get the fingerprints. That can be very threatening to people. So, you know, encouraging agencies to buy live scan machines. Those are those machines that if you've gotten TSA pre-check, you know, they basically take a Xerox of your fingers. For those non-techies among us, that's the way I think of it. They don't make a mess. Some jurisdictions use UPS stores because they're all over the country. A lot of them have these live scan machines because they're doing those TSA pre-check and other global entry pieces. So they have them, and it's a non-threatening location. Other things that can be done is training staff to really review the results. So kind of simple things that can be done to really make a difference for families. The out-of-state child abuse registry checks that Heidi talked about. So if some kin or non-kin wants to be a foster parent, lived in another state within the last 5 years, you got to go ask that other state about any child abuse findings they have in that state. Well, these child abuse registries, some states don't even have them. Some states don't have a clear way of communicating with them. There's just, again, a host of array of practices, and there's no central place that keeps track of who's got what. So what can be done? Well, simple things that can be done by your agency, which is don't require notarized signature on the request, don't require a witness signature, don't charge a fee. Even a small fee can be a huge barrier to getting it done and getting it sent back. Really accept and prioritize email requests. Like, don't make it a big thing with, like, you know, certified letters that delay things. Use a general email inbox, not someone specific, because as we all know, those people can leave. And after a certain amount of time, there's no forwarding information on that inbox. Or it just goes into cyberspace and, you know, one state thinks the other state got it, but they never got it because that person's no longer there. The Child Welfare Playbook keeps track of all of these out-of-state check improvements. And again, please feel free to share if we omitted one of your great practices, because we want to keep a close track on all of this. But you'll see that there's great progress being made in these things that just facilitate this process and the licensing of kin. I want to point out that there's new guidance so that, you know, the Administration of Children and Families keeps a child welfare policy manual online, and it contains questions and answers from the federal government around all these things. And they just put in there a question and answer around these fingerprinting issues. And they've made it eminently clear to anybody who had any questions that you Title IV-E agencies can use administrative Title IV-E funds to pay for live scan machines, to pay for staff to do it, to pay for facilities to do it. And that's all at the 50% administrative rate that you can get back from the federal government. The cost of training staff, you can do that as well. You can train your child welfare agency staff or other staff to do this fingerprinting process, and that can be claimed at the 75% rate. So you'll see a link directly to that. That just literally came out within the last few weeks. So that's hot off the press. So a number of things that can be done to help facilitate these criminal and child abuse registry checks. Some takes more time and some take less time. But as you can see, we're making progress. Heidi was just telling me she's been working with South Carolina, and she was telling me that, you know, right now what they've said, and forgive me if I get this slightly wrong, but if the kin is technically barred under their barrier crimes, not the Adam Walsh barrier crimes, but their South Carolina barrier crimes, that they're looking at that criteria that Stephen reviewed, or at least a version of it that Stephen reviewed and that I reviewed, and not just automatically barring kin. So we're seeing, you know, baby steps, big steps all around the country. I think it's a real time of movement. It's been very exciting to see what's going on and how much more kin are agencies are attempting to support kin. So know that we're here. On the next slide, you will see, I believe, our contact information, if I've gotten this order correct. And, you know, we're all available to assist and answer questions as needed. And as you can see in the chat, there are other resources as well. So now we have some time for some questions. Feel free to drop them in the chat, and we will answer them. And here come my colleagues right now. I'm just scanning the chat to see if there are any hot burning questions right now. I don't believe so, unless I overlooked something. Did I, Heidi?
No, I think we got a great question about which states have taken up the kin-specific licensing standards, and we have a map that we're going to keep updating. On that map, you can click on most of the states and or tribes and see their policies and laws so that you can compare. The other thing I'll add is there's also on grandfamilies.org under that kin licensing topic, a crosswalk tool you can use to compare your current standards with the model standards. And if you need assistance in doing that, let any one of us know. And it's the kind of thing that we're happy to help with. I think barrier crimes seem to be the biggest issue, really, in getting states to move forward on their kin-specific standards, which is why we spent a lot of time kind of digging in deep on this very topic to see where states are. But I think that was it for questions. Anything else? Please feel free to put it in the chat. And thank you to Colorado for updating us. As we said, it came out, I think, in January, and we've not been able to keep track of all the states that have made changes. So I'm thrilled to hear that Colorado has made some positive changes as well with regard to their barrier crimes. I do think states like South Carolina, they feel like changing their barrier crime statute is the first step toward adopting these kin-specific standards. Because if you have a statute that kind of limits you to all these crimes, you kind of need to face that head on so that you can license more kin when it's safe and appropriate, especially if you're one of those states on the map that goes way beyond Adam Walsh.
Yeah, and I mean, like Heidi and I have talked about over the years too, we suspect a lot of this going well beyond Adam Walsh is simply that it's hard to align a state's criminal code with a generic murder, right? Because murder is felony murder, you know, listed in Adam Walsh, aligns with murder 1, murder 2, manslaughters, you know, where do you draw the line? So really having those people from your jurisdiction that know the criminal code and how to align it with federal requirements, I think is really useful in a working group.
And I was on a call with a state yesterday, and we were talking about this very issue. And that there's that fear of liability. We're going to place them in a home with somebody who's got this criminal background. And instead of saying, okay, but looking at the criminal background from sort of a practical application and the benefits of the connection with the child versus, okay, they wrote a bad check 20 years ago. Is that really the reason you don't want to allow the child to live with grandma? So, you know, states are, you know, a little risk adverse, understandably so, but trying to create a process that really makes sense and reflects what children need with regard to being able to stay with their family. And honestly, looking at these barrier crimes, not just for kin, but do they still make sense? When's the last time your state looked at your barrier crime list and said, do these still make sense, even for non-kin? So really encouraging states to do that. With the Family First law that came out, federal government put out also a model standards and a list of what licensing standards should include. And it was pretty bare bones. And I think when states started comparing and aligning with that, that was a very big step in the right direction for the federal government to say, you really should start looking at your licensing standards and thinking about, do these make sense, or are they a result of a lawsuit or a case that went bad? So we just encourage you to encourage your jurisdiction to really take a critical look at your criminal barrier list.
Yeah, and to be really transparent about it too, because sometimes when we were doing the research, they're hard to find. So if they're hard to find for trained lawyers, imagine how they're hard to find for others. They may be in a secretary's list or in a totally different part of policy. So that can be a trick too. Being really transparent about this is really important for jurisdictions to do as well. Well, we thank you all for joining us, and I don't see any questions, so I think we can give you back the gift of time. But know that we are here, that these resources are available, and that you'll all be getting them. Tomorrow, you'll be getting the recording and the slides and the other things that we shared in the chat. Of course, now we've got some questions, but really good questions. So have people had luck? Or maybe have people had luck encouraging their states to update? Good question. If anybody wants to drop in the chat, if you've had luck, but we're certainly hearing about luck. There's been some progress.
Right, and I think especially when everybody is attempting to place with kin and more placement with kin, I think that is a really good way to look at your barrier crimes. Would you want to deny a child staying with somebody they know and love and have a relationship based on this crime? So with regard to tips on how, I think doing sort of a deep dive on why the crimes that are listed were picked to begin with, a little bit of the legislative intent, but also really thinking about, is it time to update them? I also think you could look at all of the denials, like how many kin were denied because of criminal background. Is that data that your state collects? Like asking the right questions. And I will say we do have other tools. We have a kin assessment document that asks a lot of questions around licensing kin that I think is still very helpful. I'll try to drop that in the chat. And working with your jurisdiction to ask the right questions when looking at things like barrier crimes. I'm probably not as fast as others at dropping that in the chat, but it is on grandfamilies.org.
There are no requirements for what states should be collecting on denials. There's very few federal requirements around data collection, actually, and it's just getting more convoluted, to be honest. But that doesn't mean that your jurisdiction shouldn't look at this. What is the connection? That's a way to make the case too. Like, what is the connection between the safety and the standard? Let's see, we've got a question from Texas. In Texas, we're at least making progress getting more funds to help kinship families and child placing agencies with paying for background check, fingerprinting, buying fire extinguishers, etc. Progress, that's great. That's great that we are hearing good things about Texas. And that is such an important piece that we stress in the kin specific and in the narrow standards to really help license in rather than look to ways to license out. So if a family needs a fire extinguisher, if a family needs a crib, to find the funds and to help the families obtain those hard goods.
Yeah, and sometimes it's not just about what your law says, it's about how your process, what your process looks like, as Anna talked about. What does fingerprinting look like? There's so many potential good practices out there about fingerprinting in the home, making fingerprinting at the local UPS as opposed to having to go to the sheriff's office or the police station. Thinking about how you're obtaining those fingerprints and how long it takes to process them. There are a lot of states that have partnered with their law enforcement to process the fingerprinting really quickly. We have everything from 24 hours to a month or two before you get the fingerprint results back. That variety just blows my mind. It doesn't need to be like that. And so looking at the states that are able to do it quickly.
I think also thinking about who's required to get the fingerprinting. So sometimes if the kin caregivers have other children in the home, they may need fingerprint requirements or background checks if they're over a certain age. So it might make sense for like an 18 or 19-year-old, but you probably don't need like a 9 or 10-year-old to go in and get fingerprints.
Yeah, that's a great point, Stephen. And sometimes we see that they're asking that your state law is asking for everybody in the house to be fingerprinted. And we're talking about 2-year-olds. And does that make sense? So again, it's not just the list of crimes, although that's a great place to start. It's a lot of these other extra things that kind of get thrown in there when they're doing the laws. I think people know that it's hard to change a statute. So what can be done to sort of work around the statute you have? And that's where you get kind of creative with regard to your regulations and policies.
We have one more question for Liz, but before we get to that, I wanted to share Casey Family Programs supported. Michigan has taken up the kin-specific approval standards in the final rule, and they have been licensing they have been supporting relatives with foster care maintenance payment rates, but they hadn't been fingerprinting them. So they've been supporting them, but not fingerprinting them as part of that. So Casey Family Programs, to my knowledge, supported a kind of family fun days with fingerprinting there, so that they could do it in a non-threatening way, and the children, they wouldn't have to find childcare and all of that. So there are creative ways to get the fingerprinting. So Liz has another great question. She's talking about AK. Alaska.
Yeah.
Refuses to emergency license relatives because we have temporary support, 500 per kid once a month for 2 months while they get licensed or get TANF. Do other people see that happening? And I think, Heidi, would you like to run with that one?
Yes, I guess the support that happens while you're in the process of licensing, whether it's through TANF or state funded, I don't really understand why that's a barrier to becoming licensed. Is it the argument that they're already getting support so they don't need to pursue licensing? I'm sorry, Liz, I apologize. I'm not sure if I'm understanding the question. I certainly understand the problem. I'm not sure that, and there is a variety of the way states handle supporting kin while they're going through the licensing process. If this gets to your answer, some pay them in full the same rate they will once they're fully licensed, which is fantastic. I will say the federal government doesn't allow for that with federal funds, unfortunately. They did during COVID, but they don't now. But many states will do that. Other states use TANF as a way to support kin while they pursue licensing. But we are seeing more and more states, and it looks like Colorado is one of them, more and more states that will allow for a full rate during that time of provisional licensing. And so as more states are doing it, it's always helpful to sort of shame your state into, well, you're one of the only states not doing it, or look how many states are doing this, and they're finding the state funds to do it. So I apologize if I'm not getting to your question, but I think I
am. She follows up with, it's a state program called Emergency Relief Support. That's just a flat rate for up to 2 months while a family's getting licensed. But it's less money. It often takes way longer to get licensed. Yeah, no, we see people doing, jurisdictions doing that. And that's why the kin-specific approval standards kind of streamline the licensing requirements and don't have training requirements, for example. Not because we don't think training is great, but because the license has to be in place before the federal reimbursement for foster care maintenance payments can start happening, going to the family. So whatever you can do to streamline that process and, provide training after the licensure is the way to go for kin. But we are seeing jurisdictions kind of providing flat rates to get the family off their feet because, as we said, children come to the home before they get the license. So there are ways to address these financial support abyss. But the fact of the matter is the federal money can't kick in until the licensing and approval is conducted.
And I'm going to put a link in the chat to a really fantastic, the Child Welfare Playbook collects a lot of the data and information on some of these topics. So this one is how to pay kinship caregivers until they get licensed and which states are doing it and how they're doing it. So if you want to see what's happening out there for the variety of the different ways states are doing it, it might help you make a good argument for getting creative and saying, well, let's take a look at that state. They're doing it this way, and this state's doing it this way. And I'm a big fan of showing how your state's not colored in on the map, but it should be. So,
Yeah, it can go a long way to making reform, right, Heidi?
yes, I'm not above shaming. No, just kidding. So, great, excellent. Anything else? Any other questions that people have?
Well, don't hesitate to email any one of us, and we will get you that recording and the slides tomorrow. You'll get them in your inbox in the email that you registered for the webinar using. So we thank you all so much for joining us today. And yeah, please continue to use our resources, and we're here to help.
And let us know when you're doing improving and making improvements, because we want to track that too.
Yeah.
Excellent. Thanks, everybody.
Thank you all.
Thanks, everyone.